Well, the South African Federation of Trade Unions has expressed unhappiness with the Code of Good Practice that's been issued by the Department of Employment and Labour. SAFTU General Secretary Zwelinzima Vavi live with us tonight on SABC News. Good to have your time this evening, sir. So let's look at some of what would be achieved here. Labour reforms that would protect smaller companies with limited HR capabilities. New dismissal code would lower the threshold for firing underperforming experienced workers. There's a focus on employment justice and faster dispute resolution, etc., according to one of the summaries that I've been looking at. Which part of all of this do you find most offensive?
Well, there are about 6 that we have listed in our statement. The first one, in terms of the priority, is that the code is saying must be interpreted in a manner that ensures the expeditious resolution of disputes. And we quote now clause 2.2 of the code. What we are warning against is that this expeditious resolution of dispute will be seen and interpreted by the employers, by the CCMA, as meaning that we must fasten the process of disciplinary hearings to the point that they may run roughshod against the protections of workers that are inherent in our labor laws. The second clause that we find it very, very problematic is on clause 3.1 to 3. It says smaller employers may adopt a less formal approach to discipline. This will legitimize what we call the corner shop justice, creating a two-tier labor market system. Workers in a small establishment will be stripped of their rights to protection, whilst the rest of other workers are protected. On clause 5 of the Gazette, again, we quote it, it says, a dismissal is unfair if it is not effected for a fair reason and in accordance to the fair procedure. Automatically unfair dismissals include dismissal for participation in a trade union activity, for pregnancy and discrimination. This is very good. We like this. But unfortunately, that clause opened for a door to allow again the employers to abuse even that clause in order to run roughshod over the procedures that must be undertaken to protect the workers. Another clause says.
On that point, then, Mr. Vavi. Okay, finish that point and then I'll ask you my question.
It says the purpose of discipline is to correct behavior and not punish. Very good. And it says it must be applied in a progressive manner. Excellent. But this language is strengthened and it must be strengthened, but it will be rendered meaningless when it is read alongside clause 6.7 that says the employer may depart from these rules and procedures if there is a justification for doing so. And we believe that that sweeping loophole allows bosses to ignore the very protections the code claims to be establishing. I can pause because there are quite a few other examples we wanted to just mention.
I think you've given us a good enough picture of more than, I think, 3 examples of what you say are flaws in, especially, am I right, the wording, the phrasing in the code. Is it for you at this point as SAFTU just a matter of tightening the wording so that even these small employers are not able to wiggle or manipulate the wording? Is that all that you think would be needed for this to be acceptable?
No, this is not about tightening. Yes, in some areas where we are making progress and gains, you can tighten it, the language, but there are some issues that you cannot tighten yet altogether because they represent an attack, in particular for workers working for small businesses. Look at clause 7.2 of that code. It says a dismissal may be appropriate for a single instance instance of serious misconduct, meaning that the employers can now stretch the definition of serious misconduct to justify arbitrary dismissals to union activists and whistleblowers. It further says an employer may be dismissed or employee may be dismissed during probation for reasons related to performance or incompatibility. Now, we have never had a wording of incompatibility in the labor law. And that code now shifts the burden to workers and gives employers a free hand to sack new hired employees without real obligation to provide them with training, support, and evaluation.
Right.
And we think that that represents a frontal attack, in particular for workers on probation. And this is where we say that this type of sweeping statements and regulations actually open a revolving door that the employers are going to use, put workers on probation, find out that they are not compatible to their culture, to their tradition, do not even have a hearing, dismiss them, and then claim that they are not fitting well and they are not performing. Without currently, if you dismiss a worker on probation, you must have proven to the CCMA that the worker was offered training, was offered support, and that there was a fair procedure to evaluate their performance.
Right.
All of that is now being removed. And those people who think that this is good for workers must have their head read again.
Well, one of the people who thinks that this is a good move is the Deputy Director General for Labour Policy and Industrial Relations in the Department of Labour, Thembinkosi Mkhaliphi, who we spoke to a short time ago. I'm not sure if you were able to listen to the conversation. And I'm paraphrasing here that one of the things he basically said is that this code does not give the employers basically the right to summarily dismiss workers. One of the other things that he said was that SAFTU had the opportunity basically to give inputs through the NEDLAC process, but he says you did not do that. You chose instead to go public or to fight this in the street. Is that an accurate account? And if so, why? Why not object within NEDLAC and fight this there?
Again and again, let's explain. The negotiations to amend the labor laws started in 2021 when SAFTU was locked out of NEDLAC. SAFTU only joined NEDLAC in November 2022 when the process was nearing conclusion. And when we made a call that the process must restart to allow SAFTU to participate effectively in defense of its workers and its members, we were told that no, that will not happen. So we jumped into a moving train, having been kept outside bureaucratically in order to conduct these negotiations behind, in the main, the private sector workers which SAFTU represent. So that's actually what happened. When this happened, we again wrote a letter to the minister in January this year to say, Minister, would you allow more space for public participation, for public hearings, so that we can make input? Can you extend the deadline beyond the 60 days that you have offered? She acknowledged receipt of our letter. That was it. Never sought to engage with us at all. There were other 30 organizations who made submissions to the minister as part of the public hearings and who also made an appeal. Will you allow more participation in the main? Will you allow workers to participate through provincial hearings so that they can, in person, come to say to the department, this is our experiences as workers employing for small macro enterprises, for the informal sector, for the most unregulated areas of our work. allow us to have our views here.
Right.
No, that will not be entertained. And now, boo, we get a gazette on the 22nd of August to say, without even the parliament being allowed to conduct public hearings on a matter that will have profound impact on the labor relations of this country. And we're saying no to that. And that's why we would be, amongst others, appealing to Parliament to say you have to insist on your right to conduct public hearings, to allow the public to interact with these gazettes, and don't tell us that they are not laws, because these are going to be used by the CCMA, by the employers in the hearings as a guide. And when they use these very problematic provisions, workers will then find out at that moment that they have been hugely disadvantaged through these gazetted amendments
SAFTU General
to the
Secretary.
regulations.
Apologies, SAFTU Secretary General Zwelinzima Vavi. Lots to talk about, but I'm told we're out of time. Thank you very much for being on The Full View this evening.